Hi, my name is Jason Kramer, and this is the evolution of hotel liability, specifically regarding guest property. So, the hospitality industry laws and regulations find their beginning in the common law declared by the king way back in the day when taverns and innkeepers were more or less the sole participants in the hospitality industry. The common law rules were very strict and very severe. Innkeeping was considered a public accommodation, and therefore those who worked in the trade were held to the highest liability. Public accommodation means that what they did was strictly for the public and not for themselves. So it highly limited their ability to refuse guests, avoid liability for bar fights or thievery, etc. And so there is a quote from the hospitality manual, Washington State Hospitality Manual, that ad libbed essentially says that innkeepers were the lowest of the low, and were affiliated with the lowest of the low, um, but not due to their own fault, due to um, the common law, because they weren't allowed to turn people away. Thieves and thugs and everyone made their den their base of operations, the local inn or tavern. And thus innkeepers were also held to that low tier of people. As the years went on, specifically towards the early 1900s, with the invention of cars, um, common law was expanded regarding hotel liabilities, laws, regulations, etc. And they were all expanded through legislative, judicial, and regulatory action. An example of such regulatory action can be seen in the case study outlined on the right. It's the City of Los Angeles versus Patel et al. It was a local ordinance put in place by the City of Los Angeles, forcing owner operators of hotels to show their guest registry to police on demand with no warrant. Um, it was determined to be unconstitutional by the Supreme Court, as a violation of the Fourth Amendment right to unreasonable searches. This is just one of many cases where a local ordinance or a city ordinance is deemed inappropriate by higher state courts or state legislatures, and the proper actions are taken. In this case, it increased privacy rights for hotel guests, which was a big win on their part. But the reason why a Supreme Court decision has effect on hotels is because with the invention of cars and the increase in interstate commerce, interstate travel, the hotel industry, the hospitality industry in that regard was deemed to be part of interstate commerce. And as a industry that participates in interstate commerce, they are subject to federal regulations, not just state and local ordinances. So, in regards to property, common law versus modern law, back in the old days, common law, innkeepers faced total liability. They were completely responsible for their guests, not limited to their person, but also their property. If there was a bar fight, if someone was killed, if their belongings were stolen, it was entirely on the innkeeper to make sure that their guests were safe and their property was safe. Think about traveling back in the day and going to an inn with your few measly possessions and waking up and they were gone, uh, because distance was few and far between inns. People expected that they could go to sleep and wake up and be alive and have all of their stuff and not be robbed. in the tavern itself. Outside of the tavern's another story, but inside it was entirely on the innkeeper to make sure that people were okay. Nowadays, hotels face much more favorable liability protections. They're still responsible for guest property, but it's highly limited, and principles of bailment apply in select situations as well. This is due to, in my opinion, extreme lobbying from a $5 billion industry in the United States alone. Rules have been put in place in Washington state. Hotels can avoid significant liability by providing a safe either in the room or the actual hotel safe for guest valuables, and by posting appropriate signage in regards to the state code, their liability can be limited all the way down to $1,000. So no more than $1,000 for valuables. Other goods, suitcases, clothes, everything has a cap on it. There's no endless liability for hotels anymore, as long as they follow, at least for the state of Washington, the state code, and it would also apply to other states as long as hotels followed the applicable rules in the state codes, that their liability could be limited as well. I mentioned principles of bailment apply in select situations because not everyone who is a guest at a hotel stays at the hotel, leaves their belongings at the hotel. Bailment applies if you leave your bags at a hotel while you walk around the city for the day. If you leave your coat at a coat check. Even in situations like this, there is limited liability that hotels face, depending on the state. For the state of Washington, there is limited liability. Other states, I can't speak to. So the impact of the evolution of liability is that the laws are always concrete and they're always affecting different sets of people in either positive or negative ways. With the increase in liability for protections for hotels, it affected guests' ability to recover if they have valuables stolen, things damaged. Essentially, anytime the hotel proves that they acted in good faith within the context of the law, the guest has very little legal recourse to recover on their valuables. However, there are laws that have favored and remain favorable to guests, such as if their stuff does get stolen, if the hotel can't prove they acted in good faith, they do have ways to recover. They're still responsible for your person in the event that you fall sick while on the premises. They have to take care of you. A lot of the baselines of common law still exist today, and those common laws are applied in places where modern laws haven't touched on yet. So, to summarize, at the end of the day, well, yes, there has been an evolution. There has been limited liability. You still have a means of recovery in the event that something happens at a hotel. It may not be as much as it once was, but you can still recover. And hopefully we continue to see liability laws evolve and change as the times continue to change. And maybe one day they will become more favorable to the guest once again. Thank you very much for listening. And that's my presentation.